welcome to the Probate Law Group show. This is Michael Koberlein coming to you from Mesa, Arizona, and talking to you today about the probate process defined. The way that we're going to go through this is by going through several different probate terms and talking about what they mean. So to begin, we will just talk about the probate process in general. Probate is the legal process through which the court reviews the last will and testament of someone who has died. When we consider someone who has died, most probate attorneys will say the word decedent, and that is just referring to the person who died who left their estate behind. If there is no will, in other words, if the person dies intestate without a will, then statutory rules govern who gets what. Probate is necessary if the decedent's estate has real property with equity of $100,000 and or has real property or has personal property that is valued in excess of $75,000. Now, this is true in Arizona. Other jurisdictions may or may not be different. A probate is initiated by filing an application with the court to probate the will. It's necessary to file with the court an application for appointment of a personal representative as well. Personal representative, generally speaking, is that person appointed to handle the affairs of the estate. The personal representative is a gender-neutral term. In days past, you may have heard the term executor or executrix. Those would also be the title of people who would handle the affairs of the estate, executor being the male and executrix being female. Okay, so let's move on and talk about some more specific terms. Informal probate. What is informal probate? Informal probate is the process that requires minimal court supervision and, generally speaking, no court hearings. A court officer called a registrar may act without a hearing to validate the will. The registrar may also appoint a personal representative without a hearing. This process usually takes approximately 6 months to a year. And when I say this process, I'm referring to the informal probate process. The will must have self-proving provisions to qualify for the informal probate process. Self-proving provisions would be the will must be signed and notarized. A formal probate process. So now we're talking about formal probate. Formal probate involves more complex and actual in-court proceedings in front of a probate judge or commissioner. Legal issues related to the will typically trigger formal probate. So if there's some type of contest between the parties over whether or not the will is valid, differing interpretations of the will, fights between family members over who's going to be the personal representative or the executor. These are all reasons why you may, instead of having an informal probate, would have a formal probate. This process almost always takes more time than the informal process. And because it takes more time, it costs more money in attorney's fees. As we just mentioned briefly, a registrar is the county employee who takes care of the judicial duties and administrative functions of the probate court. Probate documents are filed with the probate registrar and routed to the judge or commissioner as needed or required. The probate registrar uh, essentially allows for informal probate to go more smoothly, or at least that's what we would hope. We talked a little bit about a personal representative earlier. The personal representative is the individual named in the will or determined by statute in the absence of a will. Again, that word absence of a will is referred to as intestate. A personal representative is placed in charge of administering the estate. The probate judge, commissioner, or probate registrar must appoint a personal representative. They can't just appoint themselves. The court appoints the personal representative in a document called letters of appointment. These letters legally authorize the personal representative to act in the name of the decedent. A personal representative is a fiduciary. This means the personal representative has the fiduciary duty to act without bias for or against the beneficiaries and creditors involved with the estate. The personal representative also has a duty to protect the assets of the estate. The following people who have to be over 18 years of age may be considered as the personal representative. A person who is named as personal representative in the will, the surviving spouse of the decedent or the person who has died, an adult child of the decedent, a parent of the decedent, a brother or a sister of the decedent, a person entitled to property of the decedent, and a creditor if at least 45 days have passed since the decedent's death. So a creditor may also be a personal representative of that individual's estate as long as 45 days has passed since the decedent's death. Another definition from probate is waiver and consent. Waiver and consent. Individuals who have any right to appointment as personal representative may sign a notarized waiver and give their permission for another person to act as personal representative instead of them. This does not mean that that individual will automatically be appointed as personal representative, because there are other interested persons who may still contest that appointment. Such waiver and consent must be sent to all interested persons to let them know what's going on. Although who gets appointed as personal representative can be contested, it is generally in the best interest of all concerned for the parties to come together and agree upon who should serve as personal representative. Again, the reason for that is because if there's fights involved in probate, then guess what? That means that it takes more time and it takes more money. Speaking of money, the next definition, probate bond. Probate proceedings may or may not require a bond. If required, the personal representative must post a certain amount of money as bond, sometimes referred to as a probate bond or an executor bond or administrator bond. And if the estate is worth, let's say the estate is worth $500,000, and this is not exact math, I'm just throwing an example out there of what it might be like. If an estate is worth $500,000, a surety may sell a bond for approximately $1,500 to the personal representative, which bond is purchased with estate funds. The bond operates, excuse me, the bond operates as a type of insurance for the beneficiaries of the estate against the personal representative's failure to meet his or her fiduciary obligations. In other words, if the personal representative fails in their fiduciary duty to protect the assets of the estate, and as a result, the value of those assets decreases, then the beneficiaries can bring a claim against the bond. If the surety decides it's a valid claim, then the surety would reimburse the heirs for their loss, and then the surety would go after the personal representative that breached their fiduciary duty, and the surety would go after them for the amount that they paid out to the beneficiaries. To avoid all of that mess, it's commonly done either in the last will and testament or by the unanimously by the beneficiaries to waive the bond. Often, if it's written in the last will and testament, then the courts will accept that as a bond waiver. If it's not in the last will and testament, then the court requires a bond unless in Arizona, you can have all the beneficiaries sign a form and waive bond, and then the court will allow for a bond waiver, and the personal representative doesn't have to secure a bond at that point. Mentioned earlier, a decedent. A decedent is a person who died and left behind an estate. So anytime you hear that word, that's what it's referring to. A lot of people don't understand that they do actually have an estate. An estate is something that, again, everybody has. The definition of an estate is an estate consists of the assets and liabilities left by a person at death. This includes all their money and property, all the land and real estate they own, possessions, financial securities, cash, physical tangible assets, collectibles, and furnishings. So, if you have a house, or if you have a car, or if you have clothing, or if you have jewelry, or if you have furniture, you have an estate. Some people have larger estates than others, but an estate is essentially the things that you own, the things that you have. The probate estate is only those assets that are subject to probate, which means that not all assets are subject to probate. The taxable estate includes other assets that may pass outside of probate through a trust or beneficiary designation or otherwise. Often people use the word estate to and mistakenly refer to both the probate estate and the taxable estate by just saying estate. However, this is something that will sometimes cause confusion. So we have to be clear at what is the probate estate and what is the taxable estate. I mentioned letters of appointment earlier. Letters of appointment can also be referred to as letters testamentary. These are documents issued by the probate court that state the name of the individual authorized to act as personal representative in the administration of the decedent's affairs. It also may sometimes include limitations if the judge sees fit to limit the personal representative's scope of representation. Some more common words that people may not know the exact definition to. The word heirs. An heir is a person legally entitled by blood, adoption, or marriage to the property or rank of another upon that person's death. Devizee or devisees. This is someone who receives real property as opposed to personal property from the estate of another. So a devizee is someone who receives real property, like a house or land. We mentioned interested persons earlier. Interested persons are heirs, devisees, children, spouse, creditors, and others who have a property right in or claim against the estate. Additionally, persons having a priority for appointment as personal representative qualify as interested persons. Some examples include a person who has filed a demand for notice with the court, personal representative of the decedent who has a current appointment, a spouse, adult children, parents, brothers, and or sisters of the decedent, a person named as an heir of the will of the decedent. So those are again examples of interested persons. If you hear that phrase interested persons, that's what it's referring to. So those are some of the phrases or definitions that are included in probate. You may ask yourself if I can do probate on my own. Certainly, the law does not require an attorney to be involved in the probate process. The courts provide self help forms, and in simple cases, a non attorney can take care of a probate without any issues. At the same time, there are court rules and requirements that must be followed. Failure to do so can have significant consequences. Particularly if there are disputes or complications, the assistance of an attorney in probate is a very good idea, if not a necessity. Probate Law Group offers complimentary initial consultations to help you determine whether or not the assistance of an attorney would be beneficial or necessary for you. Please call us at 480 535 8000 to schedule an appointment. Thank you for listening to Probate Law Group.